Hi, I'm Raiford Palmer, managing shareholder of SCG Divorce Law and best-selling author of I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds, available on Amazon and where all ebooks are sold, also on Audible and audiobook. This video, I want to talk to you today about case resolution options, and that is those of you who are questioning about how you can get an uncontested divorce or how you might have an amicable divorce. Those are really important questions, and I think there's a lot of misinformation out there and misunderstanding about how that can be accomplished. So we're going to talk specifically about Illinois because I'm an attorney in Illinois in the Chicagoland area, but these case resolution options generally are applicable anywhere in the United States. So we're going to talk about the main resolution options, and today we're not talking about litigation because that's not an amicable divorce. It can turn out to be amicable, I suppose, but the options for you for an amicable or uncontested divorce really are collaborative law, mediation, and arbitration. So first, we will start out with collaborative practice. So collaborative practice was invented by a divorce lawyer named Stu Webb from Minnesota about 20 plus years ago. Stu Webb was a divorce trial lawyer who was sick and tired of trying cases and fighting in the trenches and thought there must be a better way. So he talked to an attorney friend of his and they decided to try a better way where they would agree to stay out of court and they would negotiate in a series of meetings and try to work out a settlement between the parties without proceeding to court. And the unique innovation Stu Webb brought to the collaborative process, he really developed it. In fact, he has a book out there about collaborative law. The unique part about collaborative law is in pure collaborative practice, the parties sign what's known as a participation agreement. The participation agreement is a contract between the two parties, the couple getting divorced and their attorneys, and other members of the team, such as divorce coaches and financial neutrals and other professionals, which I will describe shortly. So those folks sign the participation agreement, and the agreement provides for confidentiality in terms of the things that are said in the meetings between the parties and among the professionals. The stuff is confidential and can't be discovered if the case later goes to court. The participation agreement also provides that in the event either party proceeds to court, the attorneys are fired from the case and both parties need to get new attorneys. The reason this is a good thing is it ties everyone together. It ties the attorneys financially together with the success of the settlement. So the attorneys are discouraged from encouraging court or telling people they're going to blow up the deal or threaten going to litigation, because the attorneys then lose their clients and the clients have to go get new lawyers. Now you might think, well, that's not great because I might lose progress if I've made some progress in my collaborative case. That's not true, because in the collaborative case, the documents that have been exchanged and the information gleaned in that process are still useful for your next part of your case if, in the unfortunate event, the case ends up going to court. And also, if you've made some progress in negotiating a settlement, there's no reason why you can't continue to negotiate from there. So it isn't a complete waste of effort at that point. Now, let's talk a little bit about how the collaborative process works. So in the process, you have a series of meetings that we recommend they be no longer than 2 hours in length because people get tired. They tend to be about every 4 weeks, and there's an orderly process for each meeting with an agenda. So the parties and the attorneys and team start meeting. In the first meeting, everyone meets and talks about the ground rules for the meetings, introduces everyone, talks about goals and concerns for the parties. So what are they attempting to accomplish, where do they wish to go, and what are they worried about? Then they talk about also the nature of the process, how it all works, and set up future meetings. Then also discuss the involvement of other professionals like divorce coaches and financial neutrals. So I'll briefly explain divorce coaches and financial neutrals, and we'll discuss that more in a later video. A divorce coach is a mental health professional like a psychologist or a licensed clinical professional counselor who is trained in divorce coaching and collaborative practice, and they can be involved in the process kind of to whatever degree the parties wish. Some parties share one divorce coach, and other times each person in the couple will have their own divorce coach. The divorce coaches are not used for therapy purposes. The coaches aren't there to help you determine what went wrong in the marriage or to try to help you with your other issues in your life. The divorce coaches are there specifically to help with the collaborative process, to help both people understand each other, communicate with each other, communicate with their children, and deal with the attorneys in the process. So for example, if the people in the case during the collaborative meeting get into a disagreement or argument about something that's really emotional in nature and not legal, The coaches can work with them to sort that out at a lower hourly rate, by the way, than the attorneys. The attorneys are not professionally trained in counseling or in communication. The counseling people, the psychologists and divorce coaches are trained in that, and they're a better person to work with the parties on those issues. I've found in my career they're very, very helpful, both in litigated cases and in non-litigated cases as well. So now we will move on to financial neutrals. A financial neutral is a trained financial professional, sometimes an accountant, sometimes a wealth management professional, who is also trained in collaborative practice and is usually a certified divorce financial analyst. These people are used to gather the financial information from both parties and prepare financial models that are used for the financial portions of the settlement discussions in collaborative practice. The financial neutrals work largely outside of the meetings, but also typically attend the settlement meetings either remotely by Zoom or in person to help the discussions regarding the financial situation of the parties and explain the assets, liabilities, income, and expenses, and discuss the financial models set forth, for example, division of assets and debt, and for support scenarios such as alimony and child support. So the financial neutral is not deciding the financial outcome in the case. The financial neutral is a person that works with the parties and their attorneys to help figure out the solutions. So the parties, the couple in the case, drives the outcome. That is really one of the hallmarks of collaborative practice. So the parties are driving the solution, not the judge and not the lawyers. The lawyers are there to assist and obviously to guide their clients in terms of what their rights and responsibilities are, and to make recommendations about what's in each client's best interest. But ultimately, the parties are driving the solution at their pace, which is obviously a big advantage over having the court run things on the court's schedule. In my experience, collaborative practice means shorter amounts of time required to resolve cases and less expense in general. So typically you can expect in a collaborative case, the sort of typical case with some children and financial issues that aren't terribly complicated, that you can spend between 6 to 9 months to have a resolution in the case. Your mileage may vary. The case could be resolved sooner, but typically with the meetings going about every month because there's homework required between meetings and work necessitated by the professionals, that's a pretty realistic time frame to keep in mind for a typical collaborative case. You might be concerned and saying, well, with all these other professionals, it sounds expensive. I can tell you it's a lot cheaper than handling the case in a litigated system where you go to litigation in court. You'll spend tens of thousands of dollars, if not hundreds of thousands of dollars more in a full litigated divorce case going through trial than you would ever spend in a collaborative case. And it's not just the money you're spending, it's the time and emotional energy, as I talk about in my book, that's important to keep in mind. Your family will heal faster and you'll put the divorce behind you much sooner if you can use the collaborative model. Next, I want to talk about mediation. Mediation is a system by which a neutral third-party mediator helps guide the parties through the negotiating process. A couple of things to know about mediation. The mediator is not either person's lawyer and can't give legal advice. There are really two kinds of mediation practice. One is more authoritative or directive, and that's where the mediator takes a more assertive role in the process, really guiding the parties through the solutions. And then there's more of a facilitative role where the mediator is really more of a passive person who's just making sure people are playing by the rules, kind of being nice to each other. I prefer the directive model, but even with that, a mediator can't give legal advice. So that's important to know because the mediator can't tell you whether the agreement you're reaching is good for you or bad for you. And therefore, we always recommend that you use an attorney in the mediation process, though they need not be involved in the room itself during the meetings, or the virtual room for that matter. Mediation can be very valuable for certain aspects of divorce and maybe not as effective for others. For example, mediation can be excellent for parenting issues where the parties really know what they want to do in terms of, let's say, a parenting or visitation schedule. There's no need for legal advice whether parenting should be Tuesdays, Thursdays, or some other dates and splitting up holidays. That's something that's really a personal preference issue. Assuming the two people agree on custody in general, meaning that they agree that they should share the decision making, the parenting time decisions, the scheduling decisions are fairly easy to achieve and don't require lawyers to be part of that negotiation. So that's well suited for a mediation process. Not as well suited for a mediation process is dealing with complex financial issues where legal advice is really required and more extended discussions are needed with attorneys so that both people in the couple understand their rights and responsibilities and what is good for them and bad for them in a potential settlement. Mediation can be an excellent cost-effective way to help resolve a dispute, again with the caveats I've stated earlier. Also, I want to discuss arbitration. Arbitration is a process where a neutral arbitrator acts as a sort of judge in a streamlined litigation-type process. It's an alternative dispute resolution method that's typically used in commercial disputes, but has been used with some success, typically in financial disputes in divorce cases. For example, in Cook County, Illinois, there is an arbitration program. A person well-versed in financial matters is typically the arbitrator. They hear the evidence presented by the attorneys and the parties and make decisions that are binding on the parties in a binding arbitration process. This is really a quasi-litigation method. The theory is that it's more efficient than a court process, typically because court dockets, especially in a place like Cook County, are jammed and a trial can take 3 years to be resolved, potentially longer in Cook County. So arbitration is a faster way to resolve a dispute if the parties are potentially diametrically opposed on an issue and they can't reach an agreement by mediation or collaborative practice or just by trying to reach a settlement. Arbitration may be an effective way to reach a resolution of a dispute where the parties feel like they need to have their evidence heard and decided by a trusted third-party arbitrator. Arbitrators are not cheap. They usually charge several $100s an hour for their experience. But again, it can be a much more streamlined way of resolving a case better than litigation through a court. There's one final method of conflict resolution I'd like to mention that is sort of an alternative. It's kind of a hybrid, and that is what I call the one attorney model. In the one attorney model, the parties have to have a high degree of cooperation. These are people with a fairly straightforward financial situation who just want to get their case solved and need assistance and want to keep their costs very low. This is a type of case where they aren't diametrically opposed on issues such as parenting or custody, and really they just need to divide their assets, figure out what support should be, and move along efficiently. In this model, one of the parties hires an attorney, and the attorney prepares settlement documents based on what that client is telling the attorney about their wishes and their partner's wishes for the settlement. The attorney prepares all the documents and works with that one client to put together the financial division solution in draft form, along with the draft settlement agreement and similar documents. Once that stuff is all done, the attorney provides copies of all that information to the other party, along with some recommended attorneys they might want to talk to, which is optional. Then the other client reviews all that material, makes sure that it's in line with their expectations, asks any questions they may have, and then consults with their own attorney and reviews the settlement documents with their attorney to make sure that the documents in fact are what the person intended them to be. And they review the agreement with their attorney to make sure the agreement is also in their best interest and that the agreement says what they expected it would say. Then the case gets filed with the divorce court, and within a few weeks they can get divorced. This is a very low expense, very quick way to get divorced, but it assumes a high degree of cooperation between the parties. One thing to note is ethically, a law firm can only represent one person. We frequently get questions where a potential client will say, well, can't you represent both of us? Ethically, we can't do that. And also ethically, we can't give legal advice to your spouse. We can only speak with you. We can answer basic questions about the agreement, and with your permission, we can share the agreement with your other spouse. We also recommend sharing all the financial information with your spouse and laying all the cards on the table so that they feel a high degree of comfort with the proposal. Having that transparency is crucial to keeping everyone calm and making the process efficient. So in summary, we've outlined 4 conflict resolution methods for your uncontested or amicable divorce. One of those is really more of a contested model, but I wanted to explain it for completeness. So we talked about collaborative practice, we talked about mediation, we discussed arbitration, typically for financial issues, and we discussed the one attorney model. I hope you found that useful. If you have any questions, please reach out to us at stglawfirm.com. You can find me on social media everywhere at Raiford Palmer. My book is available on Amazon. I Just Want This Done, How Smart, Successful People Get Divorced Without Losing Their Kids, Money, and Minds. Available in paperback, hardcover, ebook, and Audible. Check it out. I think you'll find it useful. Also, the book website is IJustWantThisDone.com. Please check us out. Follow us on social media. Like, share, and subscribe for more information like this. Also, for you Illinois folks, we have a special Illinois Divorce Support Network on Facebook. It's a private group with nearly 500 members. Joining is free. We just ask for your email address. We don't spam you. We provide you with useful emails once a week that'll help you with more divorce knowledge like this. Check out our website for articles. And thank you very much. My name is Raiford Dalton Palmer.